Qantas has just been fined $90 million for illegally sacking 1,800 ground staff 5 years ago during the pandemic. The penalty judgment was just handed down in the federal court, with Justice Michael Lee pondering in his ruling whether Qantas has been acting the wrong kind of sorry. He also ruled that Qantas should pay at least some of this fine to the union that pushed for justice for its sacked workers.
An arm of the executive government did not show any interest in investigating or prosecuting Qantas, and the union, as a common informer, has alone borne the burden of prosecuting this litigation at first instance and on appeal.
For more on this fine, I'm joined now by Dan Trindade, an industrial relations lawyer who's been following this case closely for years. Dan, thank you for joining me.
Good morning, Amelia.
So is this a record-breaking fines, and who does it get paid to?
It's a really significant fine. There have been large fines levied, but in the industrial space, that's usually been against the CFMEU, a sort of recidivist offender. It's a very significant fine against an employer, and very significant for what the judge has said in terms of issues around contrition and remorse. So a $90 million penalty, $50 million to be paid directly to the Transport Workers Union, and the remaining $40 million, the judge has said that that's going to require some more discussion and consideration. In particular, he's raised the issue that he doesn't think, well, he's not sure that the employees have been fully compensated by the $120 million agreed settlement amount. And that is, I think, looks like he's leaning towards there might be some additional payments made towards employees.
So, Dan, lots of things to unpack here, but when it comes to the fine being at least partially paid to the union, is this unusual?
It's probably unusual because it's probably a significant windfall for the Transport Workers Union. I think that they had estimated their costs at around $20 million. So if you think about that, that's an extra $30 million to go into the union coffers to pay for its standard industrial activities. And the judge did make the observation that part of the reason for awarding it to the union was to resource the union and to give a deterrent effect to employers to say, well, I'm going to resource a union to be able to take these kind of claims on against a large, well-resourced employer.
And so we have this $90 million fine. Qantas has also agreed to pay the compensation of $120 million. But Dan, we've heard throughout this case that Qantas actually saved a significant amount of money by outsourcing these workers in 2020. Do you think on the figures that they've come out in front still financially, the company?
I think that has to be the case. I think we've talked before about the figures being roughly around $100 million a year in savings, plus an $80 million upfront capital works saving. If you look at that over 5 years, that's $580 million. Now, I think the judge has said, poured a bit of cold water on some of those figures, but he was also talking about the fact that originally it was identified as $125 million a year savings. So say it's a $500 million saving over 5 years. In total, the whole episode has probably cost them $240 million, $120 million in agreed compensation, probably about $30 million plus in their own legal fees, and now a $90 million penalty. That's about probably half of the amount of money that they saved through the exercise. So the question of deterrence is, it's really difficult to answer whether it will act as a deterrent, because if someone was just doing a pure sort of number crunching exercise, they had a $500 million cost saving on one hand and a $240 million outlay on the other side. It probably still works as a business decision.
And Dan, you watched this judgment, as did I. I noted that the Justice Lee made the comment that possibly Qantas is the wrong sort of sorry about this. There was a lot of talk about contrition. What did you make of the judgment?
It was a very interesting judgment, and I agree entirely. The wrong kind of sorry is a good way of summarising it. He talked about an unrelentingly aggressive litigation strategy. He talked about the failure of the CEO to give evidence and perhaps pointing to a lack of genuine remorse or contrition. He also talked about the cultural approach to industrial relations. And he noted all of those things in the context of saying that there must be a heavy penalty that will go towards the public interest in having a deterrent. So really significant comments made by the judge, and something that should give corporate employers pause for thought about not just paying lip service to compliance, but actual compliance with their obligations.
Well, Dan, we've gone to Qantas for a response. Worth noting there that the CEO you just noted, Alan Joyce, has since left Qantas. Thank you for your time this morning.
Thank you. Good morning.